This is Right to Life Radio with John Girardi on Power Talk 96.7 and AM 1400, a production of Right to Life of Central California. And now, here's your host, John Girardi.
Right to Life Radio is proudly sponsored by Dizon Medicine and Dizon Medicine Urgent Care Plus. This is Right to Life Radio. Thank you to the deep voice man, not the deep man voice, the deep voice man, Jonathan Keller, and then me, John Girardi. This is John Girardi, the director at Right to Life of Central California, joined by Jonathan Keller. Good to have you back on the show, Jonathan, after a week-long hiatus.
I think I'm happy to be here, but that deep man voice, I don't know about that.
The deep man voice may come to haunt us later on. All right, folks. A few weeks ago, Jonathan and I did a show in which I got furious. I was filled with righteous fury and indignation.
Those are the best types of shows.
It's honestly, I've realized I'm actually kind of good when I'm really angry on the radio, and it sort of makes me worried that this could become like my shtick and that I just get artificial. I now understand why certain talk radio hosts sort of tend to get deliberately upset.
Talk about deep-voiced men.
And angry, and that makes for more entertaining radio from them, I guess, and now I'm afraid that this is going to be me as a radio host. Anyway, we were furiously angry, or I was furiously angry, and Jonathan was standing there.
I was just joining.
He was poking the bear.
That's
and
right.
Joining me and also being very frustrated, though, at the notion that the Attorney General of Mississippi, Lynn Fitch, in the upcoming humongous case that's going to come before the Supreme Court on abortion, the Dobbs case, Dobbs v. Jackson Women's Health Organization, basically, there was a question as to whether or not the state of Mississippi, in its brief, in the Supreme Court case, Mississippi is defending its own state law. Mississippi passed a law to ban abortion after 15 weeks of pregnancy. There was a concern that Mississippi was not going to call in this Supreme Court case for the overturning of Roe v. Wade and Planned Parenthood versus Casey. A lot of people were very alarmed by this. Dobbs v. Jackson Women's Health Organization is the greatest vehicle, the best opportunity we've had to overturn Roe since Planned Parenthood versus Casey. And it's the best opportunity to overturn Planned Parenthood versus Casey. So
it's the infinity gauntlet of abortion jurisprudence.
Exactly.
Opportunities.
Yeah. If that's what we're doing, if we have to reduce it all to Marvel references.
Okay, it's the ring of power, the one ring of power. Potentially.
I will say, never enjoyed Scarlett Johansson in any of the Marvel movies, but for the first time, I feel strong solidarity with ScarJo, who is suing Disney for, I'm not sure what.
Breach of contract.
Breach of contract. So there you go. Good for you, ScarJo.
It is a great story to see.
See someone taking shots at. Okay, anyway,
it's hilarious.
Let's get back on track.
All right.
Mississippi passed a law banning abortion after 15 weeks. The Attorney General of Mississippi is defending her state's law at the Supreme Court. There was a question as to whether or not, in their brief, Mississippi would actually call upon the Supreme Court to overturn Planned Parenthood versus Casey and Roe v. Wade. This would have been disastrous because Mississippi's law is obviously inconsistent with Planned Parenthood versus Casey and Roe v. Wade. The opportunity and the time to ask the court to overturn Roe v. Wade is right now. It's not later.
Strike while the iron is hot.
What is the point of having 6 Republican appointees on the Supreme Court if not to ask for an overturn of Roe v. Wade and to do it right now? There was some concern that she was not actually going to ask for a repeal of Roe v. Wade and Planned Parenthood versus Casey. A number of people wrote some very good and persuasive and alarmed pieces, most notably Robert George, saying that Lynn Fitch, the Attorney General of Mississippi, needs to call for a repeal of Roe v. Wade, that anything less would be an enormous betrayal of the pro-life movement, an enormous betrayal of the people of Mississippi, frankly, and would be a disaster.
And to be fair, John, it was, as we said on that prior show, it was not a entirely unfounded concern because Attorney General Fitch was... It seems like now, in retrospect, it seems like she is doing a great job and she knows what the heck she's doing.
Right.
She has wisely decided, I'm going to make sure that I listen to wise counsel, but there was no guarantee at the time. I mean, she was not a national name.
Well, and she had written a piece that ran in the Wall Street Journal where she talked about, the Supreme Court acknowledged a right to abortion, and was seemingly...
It was a little concerning.
She was hemming and hawing about whether she was going to actually call for the court to overturn Roe, but it seems that she was prevailed upon to do the right thing. And Robert George's piece, I hope, had some influence on it. I think ADF's work, Alliance Defending Freedom, with a great pro-life legal organization, they did some great work, I think, to work with her and influence her to do the right thing. So she did the right thing. She called on the court to overturn Roe v. Wade and Planned Parenthood versus Casey.
And John, correct me if I'm wrong, but kind of a dynamite brief, like much better than I think.
Yeah, I think a lot of people were very pleased with it. Now,
meanwhile, NRLC says, hold my brief.
Now, meanwhile, so one of the things that, as I almost spill my fizzy water here, one of the things that interested parties who care about the outcome of a Supreme Court case, but which are not themselves actual parties to the lawsuit. So if it's a case involving abortion, there are a lot of groups that care a lot about the abortion issue and about abortion law, and they will submit what's called amicus curiae briefs. That means friend of the court briefs. So I'm not a party to the lawsuit, but I care about the outcome, so I'm going to submit this brief to ask the court for my favored outcome. Now, amicus curiae briefs are not always super important. Occasionally, an amicus curiae brief will be really influential for the justices on the court. Usually they are not, but, you never know. And if you would like, ideally, to have a lot of good, solid amicus curiae briefs bringing up good legal arguments, trying to support what the state of Mississippi is trying to do in calling for an overturn of Roe v. Wade and for the upholding of Mississippi's 15-week abortion ban.
It's generally the point of an amicus brief.
That is the point of an amicus brief, to help support either one side or another, or just to advance some legal position. A lot of people on the pro-life side have submitted various briefs in support of Mississippi's position, or even asking for more. Robert George and Professor John Finnis, one of my former professors at Notre Dame Law School, submitted a legal brief in this case in which they are calling for the court to recognize that the 14th Amendment actually guarantees the right to life of unborn children, that this is embedded in the 14th Amendment, and that the Constitution should recognize a right to life intrinsic to the Constitution. Lots of other legal scholars have asked, at the very least, for an overturning of Roe v. Wade and Planned Parenthood versus Casey to allow states to make their own laws on this question. My old professor Carter Sneed, Marianne Glendon from Harvard Law School, they submitted a brief. Rick Garnett, one of my other professors at Notre Dame Law, on behalf of the Ethics and Public Policy Center, submitted a brief on this topic. A lot of people are submitting a lot of amicus briefs that are really good. People from all across the pro-life universe. David DeLeiden even wrote a brief, an amicus brief. He's not even a lawyer. So a lot of people doing a lot of good, asking the court to overturn Roe v. Wade, overturn Planned Parenthood versus Casey, and uphold Mississippi's 15-week abortion ban.
And John, just to clarify, I mean, I'm not an attorney here, so correct me if I'm wrong, but
that's fair.
Generally speaking, when you have a case at the Supreme Court or any court, I mean, it's usually called a pleading, right? That's like something you file with the court.
It's the chief sort of legal brief. Different courts have different names for it. So,
the idea being that this isn't just like an academic discussion. You're not like having a graduate level or law school symposium where you're like, well,
you're asking.
I wonder what would happen if.
Yeah, you are trying to persuade the court to accept your legal reasoning and to give your preferred outcome. That's what you're trying to do. You're not just sort of hemming and hawing and saying, what if, and what do you think about? No, you're trying to get the court to do something. That's a very good point you're making, Jonathan, that this is not theoretical anymore. This is practically, what do we want the court to do? And so the state of Mississippi, obviously the court's going to pay a little bit more attention to them, right? Because they're an actual party to the case. But the state of Mississippi and all the amici, plural of amicus, are trying to convince the court to do what they want them to do.
Right.
Yeah.
And it's one of those things where it's easy for us as, two Joes who are talking on the radio.
Sure.
To talk about, hey, this is all the possible things that could happen. I mean, maybe the court could do this. Maybe the court could do that.
Yeah.
Maybe this would be a likely outcome.
But our speculations right now are, if we're not sure about what we want to do or what the best course of action is, then we shouldn't be writing briefs to the Supreme Court, because who are we? We're a bunch of dumb.
Hey.
We're a bunch of morons.
Hey,
we're a bunch of Joe Bag of Donuts. What the heck do we know? Now, one organization that has not grasped this is National Right to Life, about whom I am going to speak. I generally don't talk about other pro-life organizations on this show. Have I ever? I've other than to say nice things about them.
That's true.
I have talked about Jonathan's fine organization, California Family Council. I think it's a wonderful organization. I used to work for them.
Yeah.
I don't talk about other pro-life organizations.
No, and to be fair, John, there's some great pro-life organizations doing good work. I mean,
obviously there are lots of them.
There is the.
I've talked about Susan B. Anthony list.
Yeah,
I've talked about Charlotte Logerians. I've talked about a lot of pro-life organizations.
Yeah.
You'll note I haven't talked too much about National Right to Life.
NRLC.
Now, I should note, Right to Life of Central California is not in any way affiliated with National Right to Life. And you're about to hear one of the reasons why. National Right to Life submitted an amicus curiae brief to the Supreme Court in the Dobbs case. Sensible. They're National Right to Life. They're a very prominent pro-life organization. They did a lot of work to advance pro-life legislation in Congress. Members of Congress sort of looked to them for guidance on this stuff.
And when they were initially founded, I mean, they were, as they still claim on their website, but it used to be true that they were the flagship national organization of the pro-life movement.
Exactly.
I mean,
and they still retain some of that legacy, I think.
Yeah.
Whether it is deserved or not is a different question.
At one point, they legitimately had, and I want to praise their previous leadership, Dr. Wilkie and his wife. I mean, they were heroes. I mean, true heroes and champions of the pro-life movement at a time where...
Until they got kicked out.
Yes.
For no reason.
Yep.
National Right to Life, let me get to the point here. Yep. National Right to Life submitted their amicus curiae brief to the Supreme Court. In this brief, they call for the court to clarify their rules for interpreting abortion law, to provide a roadmap forward for states, to give them better guidance. Here's what they don't ask for. Overturning Roe v. Wade, overturning Planned Parenthood versus Casey, or explicitly upholding Mississippi's 15-week abortion ban as constitutional.
Oh, why would you call for that in a
National
Supreme Court case?
Right to Life, who for the last 48 years of its existence has had as one of its chief goals the overturning of Roe v. Wade, did not ask the Supreme Court in the case to overturn Roe v. Wade. That's what this case is. This is it, guys. This is the opportunity. If the court decides it the right way, then we overturn Roe, and every pro-life state in the union can pass laws to severely restrict abortion. This is the moment, okay? It's not tomorrow. It's now. We don't know if tomorrow, Clarence Thomas keels over from a heart attack. We don't know if tomorrow, Amy Coney Barrett gets run over by a bread truck. I don't hope for any of those things, but you don't know. What's the point of pro-lifers voting for pro-life or allegedly pro-life presidents to nominate allegedly originalist justices to the Supreme Court? It was to overturn Roe. That's why the Republican Party got pro-lifers to vote for them. That's the point of all this. National Right to Life is not asking the Supreme Court to overturn Roe v. Wade or Planned Parenthood versus Casey. They say in their brief that they want to provide the court to provide a roadmap, that the court does not need to decide this right now, that future courts can decide this. If I was angry 2 weeks ago at the Attorney General of Mississippi for what I thought she might do, understand my unbridled fury at National Right to Life for what they did.
Yep.
And when we come back, I'm going to talk about it more just so I can plaster on every single media forum that Right to Life of Central California has that we are in no way affiliated with them and are in fact disgusted with this. We'll be right back on Right to Life Radio right after the break. John Girardi and Jonathan Keller back with you here on Right to Life Radio, a production, as always, of Right to Life of Central California, rtlcc.org. Jonathan and I, with an angry episode this week. Perhaps one could even say an utterly furious episode this week. We are talking about the upcoming Supreme Court case, Dobbs v. Jackson Women's Health Organization. This is a really, really, really important case. This is the case in which the court could very well overturn Roe v. Wade, and we are perplexed, befuddled, perplexed at why on earth National Right to Life, the National Right to Life, in its brief to the Supreme Court, asking them, well, not asking them, in their brief to the Supreme Court in connection to the Dobbs case, don't ask the court to overturn Roe v. Wade and Planned Parenthood versus Casey. It's utterly and completely befuddling. Jonathan, and it's a thing where I don't like, look, I don't like internal pro-lifer squabbles.
I can confirm this. Johnny is not one of the people that goes to all these secret pro-life meetings and has all the hot goss.
I don't talk bleep about people behind their back. I don't do any. And look, I'm not going to make any other comments on National Right to Life. I'm not going to bring up the fact that their website looks really janky. I'm not going to look up the fact that their logo hasn't been changed in 30 years. I'm not going to look up the fact that they see. Anyway, and I'm not going to bring up any of that. Okay, I'll bring up those things. Those are just little things.
I come not to praise Caesar, but to bury.
Yeah. Here's what I do want to say, though. What is the point? What is the point of being a pro-life organization given the opportunity to overturn Roe v. Wade and Planned Parenthood versus Casey and not to take it? And I mean, I dug into this a little bit more. Jonathan looked into this. I mean, their lead attorney for this,
who wrote the brief, he's been their general counsel since 1978. At which time Jonathan and I were not even a twinkle in our father's eye. 1978 was the year my parents literally got married. I mean, that's how long ago.
I don't know if I'm trying to remember if my parents had met in 1978. Anyway,
during the Carter administration,
I think they might have been in medical school. Anyway, so
but there you go. Literally the general counsel since the Jimmy Carter administration.
Yes. Right to Life has had the same lawyer since the Jimmy Carter administration. And
National
Right to Life. So, I guess I don't even know what more to say about it. Just, I am frustrated at the notion that anyone could be so timid and offer John Roberts such a path. Look, when people ask me, is John Roberts really going to overturn Roe v. Wade? My answer consistently is no. I don't think he's going to. I think if we get Roe v. Wade overturned, I think the most likely outcome is a 5-4 decision in which John Roberts wusses out. I think John Roberts is likely to try to find, and look, this is consistent with what he's done in a lot of other culturally significant cases, most recently the Fulton case out of Philadelphia. John Roberts, I think, is likely to try to find some sort of substance-neutral middle ground where he's not going to give us a decisive victory, and he's going to find some neutral reason to just punt on the substantive issue. That's what he's been doing time and time again. He's been punting on substantive issues in order to not give controversial social conservative issues a victory. Consistently pushing aside, punting on the issue of whether the Little Sisters of the Poor ultimately have to comply with the HHS mandate. Punting again and again and again, whether Jack Phillips, who runs Masterpiece Cake Shop, whether he has to bake cakes that celebrate gay marriage or other things that he does not believe in conscientiously, and punting on the issue of whether Catholic social welfare agencies have to place foster children or adoptive children into same-sex marriage homes against their religious convictions, and I am sure he's going to try to find a way to punt on the substantive issue of whether states can ban abortion before fetal viability. And what National Right to Life did is give him a roadmap for how to do that.
Why should we have to decide this, John? Why if I'm a Supreme Court justice, what
Right.
like
Who am I to judge?
Yeah.
As my job as a judge. I mean, like, the fact that National Right to Life is almost perfectly playing into the very threateningly likely outcome that we all want to avoid. Like, why would they do this? We aren't going to have another option. Now, when we come back, I'm going to talk a little bit about some of the good arguments that have been made. We'll look at a bunch of those right after the break. This is Right to Life Radio, right here on Power Talk 96.7 AM 1400. All right, we are back on Right to Life Radio, right here on Power Talk 96.7 AM 1400. John Girardi and Jonathan Keller here with you in our righteous fury that at pro-lifers who are not asking the Supreme Court to overturn Roe v. Wade and Planned Parenthood versus Casey. We are extremely disappointed in National Right to Life, an organization with whom Right to Life of Central California is not affiliated. Let me repeat that, not affiliated. And I wanted, instead of focusing on the negatives and focusing on their brief, I would like instead to focus on a really excellent brief that has just come to my attention from an author I really very deeply respect, Joseph Della Penna. Okay. Now, Jonathan, you may not know about this.
Sitting up in my chair.
Throwing curveballs at you.
Yeah.
Okay. So who is Joseph Della Penna? Joseph Della Penna is one of the most important, has authored one of the most important books on the abortion issue ever.
All right.
Okay. In the United States and in American law. Joseph Della Penna was a professor at Villanova Law School for many, many years. And he wrote a book called Dispelling the Myths of Abortion History. It is an enormous book. In fact, I wish I had thought of this. For those of you watching the show on YouTube, I should have brought it with me because it's sitting in the office across the way from here. It's an enormous, big, fat book. And I'll let him sort of speak for himself. What Joseph Della Penna did was write about the whole history of American, the whole history of the American posture towards abortion at the time of the founding and throughout American history, particularly around the time of the ratification of the 14th Amendment. And his thesis is that the Supreme Court in Roe v. Wade accepted a false history, an incorrect and incomplete history of how abortion had been treated in American law. And that this false history had led to the court deciding Roe v. Wade wrongly. Okay, so I'm going to read a little bit of the summary from his argument in his brief. So here's what he says. The majority in Roe v. Wade, influenced by deliberately distorted presentations of the history of abortion laws that have also been pressed upon the court in subsequent cases, erroneously concluded that abortion was not a common law crime. This was one of the big holdings, but this is John Girardi talking. This was one of the big holdings in Roe, was that, at common law, so America is what's called a common law country. We are part of the English legal tradition, which basically has our laws are judge-made law. It's a system of law in which judges would look at cases and controversies, issue decisions, and through a tradition of handing down decisions, developing doctrines about how we define certain kinds of crimes in a system of precedence from one judge to the next judge to the next judge, we have developed a lot of the key terms and doctrines and black letter law definitions for our law, okay? So when you say something at common law, British law thought blah, 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 blah. So this is going back to roughly before the time of the American founding. At the time of the American founding in the 18th century, American law basically incorporated to itself as decisive English common law. And a lot of our legal definitions that we have still to this day, our definition of murder, for example, comes to us from the English common law. Our definition of burglary Burglary is breaking and entering at night with intent to commit a felony inside. That comes to us from common law. And so common law was not like a code. It wasn't like a body of statutes. Here's the murder statute. Here's the this statute. Here's the that statute. It was not all compiled in like one book. It was a series of judicial decisions, okay? So at common law, we didn't have statutes on the books saying abortion is wrong. At the time of America's founding, we didn't have statutes on the books that said abortion is wrong. Abortion is illegal. Eventually, in the 19th century, we would get statutes like that. But at the time of America's founding, we didn't have those kinds of laws on the books. And so the Supreme Court in Roe thought it was very significant that abortion was not viewed as a common law crime. And this buttressed the court's notion that abortion is something that's a private individual decision and that's something that it's something to which people should have a right.
So it sounds like, John, correct me if I'm wrong, but it was a little bit of an argument from silence. They're saying, look, we don't find it in the common law, so
sure.
Hey.
Or even arguments from genuinely distorted history. So what Joseph de la Pena showed in his book was that actually, no, abortion was highly disfavored at common law. Here's what he says. Instead, the historical record shows that A, abortion and other killings of unwanted children were condemned by all respected legal authorities in England from the start of the common law, and B, those laws were applied with full rigor in the United States during the colonial era and into the 19th and 20th centuries, including when the 14th Amendment was adopted. And for those who don't know the significance of that, the 14th Amendment and its due process clause, no state shall deprive anyone of life, liberty, or property without due process of law. The 14th Amendment is the chief justification on which Roe v. Wade and Planned Parenthood versus Casey sit. Okay? De la Pena continues. When viewed through the proper historical lens, this leg on which the Roe majority rested collapses. Abortion was a common law crime from the earliest recorded days, and the common law was followed and codified in the states and territories in order to protect the life of the unborn child. Drawing a line at viability of the fetus has zero support in abortion history. The court should uphold the challenged provisions of the Mississippi statute based on its valid and important purposes mirrored in the common law. Now, I want to give my theory about the person to whom De La Pena may be writing this. Now, maybe De La Pena is just, this is what I think. I'm writing this to the Supreme Court. But I think there might be one person who really needs to read this. And his name is Brett Kavanaugh. Allow me to explain why. When Kavanaugh was nominated, and I remember you and I, Jonathan, sort of saying, I mean, that was kind of our reaction to Kavanaugh's nomination.
We were less than thrilled. It was
if anything,
not as bad maybe as it could have been, but...
Right. If anything, I think, not very well substantiated charges against him, in some cases laughably unsubstantiated charges against him, if anything, made us sort of support him more, because I sort of thought that Kavanaugh was being completely railroaded in a completely unfair way.
Yes.
One of the things, though, that gave me hope for Brett Kavanaugh that he would do the right thing when it comes to abortion, one of the things that really gave me hope was a speech he gave to the American Enterprise Institute. And he gave this speech back in 2017. I think it was like the year before he was nominated to the Supreme Court. He was a judge on the D.C. Circuit Court of Appeals, obviously a very prominent judge. A lot of people thought he was on the short list for the Supreme Court. And Kavanaugh gave a speech about a very important Supreme Court case called the Glucksberg case. Okay. Glucksberg could have been the Roe v. Wade for physician-assisted suicide, and it wasn't. Okay? Glucksberg was a case decided in the 90s, written by the majority opinion written by Chief Justice Rehnquist, and it kind of put some reins on this notion of substantive due process. Okay, so the 14th Amendment of the Constitution, all the southern states had to ratify it in order to come back into the Union. They had to ratify that, along with 13th Amendment prohibiting slavery, 15th Amendment making black people citizens and voters. And the 14th Amendment had this provision on it called the Due Process Clause. Basically, no one can be deprived of life, liberty, or property, meaning no one can be executed, put in jail, or fined, without due process of law. So basically, this was the federal government imposing a requirement on state governments. Hey, you guys have to have due process of law. You have to have fair judicial procedures. Okay? You can't have one really fair system of justice for white people and another really unfair system of justice for black people. All right? That was basically what the court was trying to do. From that phrase in the 14th Amendment, however, liberal justices in the 20th century constructed a whole series of crazy constitutional rights that are totally divorced from anything connected to the history or tradition or legal tradition of the United States. A legal right to abortion, found nowhere in the text of the Constitution. A legal right to gay marriage. All kinds of stuff. Substantive a right to privacy that's completely unmoored. In the Glucksberg case, Chief Justice Rehnquist put a profound limiting principle on when you can find a substantive right emanating from this procedural guarantee. Now, Scalia didn't necessarily agree with this. Scalia over time came to say, well, no, the 14th Amendment is just protecting procedure. It's not creating new substantive rights out of thin air. Now, liberals had this theory, well, unless a right to privacy exists, you can't have fair processes. So we create a right to privacy. And inside that right to privacy is a right to abortion. It's almost like peeling back layers of an onion. A mystical onion that's not actually in the words of the Constitution. Anyway. But what Chief Justice Rehnquist did was put a limiting principle on what kinds of substantive rights you could just cook up from the 14th Amendment Due Process Clause. And the big limiting factor he put on it was that you cannot, this court should not be creating or discovering new rights unless they are intrinsic to a system of ordered liberty and inherent, a necessary part of the history and legal tradition of the United States of America, consistent with our history and tradition. The history and tradition thing was the key contributor to the Glucksberg decision from Rehnquist. Because of that, Rehnquist determined, no, there's no right to physician-assisted suicide. It has nothing, that's completely made up. It's totally unmoored from our history and tradition. There's no right to physician-assisted suicide. There's no history in this country of a right to physician-assisted suicide. We're not going to discover it somewhere hidden in the 14th Amendment. Kavanaugh loves the Glucksberg decision. Gave a whole speech praising the Glucksberg decision and specifically said in that speech that if Roe v. Wade and Planned Parenthood versus Casey had been decided according to the Glucksberg standard, those decisions would probably have been decided differently. And that always was my seed of hope for Kavanaugh, that he would do the right thing, is basically because he would look at that Glucksberg standard and say abortion is not inherent in the history and tradition of this country. Joseph Della Penna's history of abortion law, which he is inserting into this discussion through his amicus curiae brief, is, I think, a direct shot to Brett Kavanaugh to reassert to him, no, if you're going to look at this through a Rehnquistian lens, I don't know, how do you adjectivize Rehnquist? I don't know. If you're going to look at this through the lens of the late Chief Justice Rehnquist, an original dissenter in Roe, I will mention that that's one of Chief Justice Rehnquist's great claims to fame. He was one of the dissenters in Roe v. Wade. If you're going to look at this through the lens of Chief Justice Rehnquist, understand that the history and tradition of this country is not one in which people were just going off and having abortions all the time and the state totally didn't care. No, the consistent history, legal history of this country from the colonial era all the way through the Civil War, at which point all the states codified, that is, wrote explicit statutes outlawing abortion. The whole legal tradition of this country from the colonial era to the 19th century statutes outlawing abortion that essentially every state in the Union passed was one of just consistently, no, abortion is wrong. There is no legal right to abortion. inherent in the common law.
So, in other words, if the Supreme Court viewed that and they took the long view of history, not the stare decisis view of, we can't
really
overturn
relied
it
on this,
because
yeah.
it's but if they took the long view, they said, yeah, this is bad, but this is actually just a 50-year aberration from the 200, 300, 400, depending on how long you want to reach back.
History of America.
Right.
Yes. And so I think Joseph Della Penna's brief is really interesting. It's really important. And I thought, why not talk about it to all of you here? When we return, we're going to look at maybe some more briefs that have been presented to the Supreme Court in the Dobbs case. We might look at one that was presented by my old professor, John Finnis, and our friend, even though we've never met him, Robert George. We just think we would probably be friends with him.
To be fair, I have met him one time.
I have met him one time, too. He's very short. We'll be back on Right to Life Radio on Power Talk. Back with you on Right to Life Radio, John Girardi and Jonathan Keller. All right, Jonathan, we're doing basically just going through a whole bunch of briefs that people have submitted in the Dobbs v. Jackson Women's Health Organization case.
And it's crazy. If you look at SCOTUS blog, I'm trying to count up here. There's like a bunch that look pretty good.
I haven't heard about any of the liberal ones being submitted. I'm sure there are bazillions of them.
I haven't seen any yet on here, unless I'm reading it wrong. But that's the crazy thing. Looking at this, like almost every brief I think that has been submitted so far is conservative. Is from pro-life.
Pro-lifers.
Yeah.
And from NRL, National Right to Life Committee, which does not actually ask the Supreme Court to overturn Roe v. Wade. Anyway, not that we're bitter about it. All right. I want to end by talking about one of these briefs that have been submitted. We groused very angrily about National Right to Life Committee's brief, in which they don't actually call for the court to overturn Roe v. Wade and Planned Parenthood versus Casey. By the way, Right to Life of Central California, no affiliation with National Right to Life, and certainly not going to after that stink bomb of a brief. We talked about Joseph Della Penna's very interesting brief about the history of abortion and how Roe v. Wade was premised in part on a flawed history of abortion, which I thought was kind of important and aimed at Brett Kavanaugh. I want to end by talking about a brief submitted by John Finnis and Robert George. Now, John Finnis is one of the most important English legal philosophers alive in the whole world, certainly in the English-speaking world. He is from Australia. He was a professor at Oxford and at Notre Dame Law School. He's a member of the Pontifical Academy for Life. I took a class from John Finnis, and he's probably the most famous philosopher person that I know. I got to take a class from him and Amy Coney Barrett, and they are about as big a deal. I guess she is more of a big deal just because she has more power than John Finnis does. Anyway, he and Robert George submitted a brief about the 14th Amendment, that the 14th Amendment should be understood as protecting not just walking around people, but also unborn children in the womb. So one of the things the 14th Amendment says is that no person shall be deprived of life, liberty, or property without due process of law. Now, while chiefly this is a procedural protection that don't have unfair legal procedures, it does basically prohibit states from having laws on the books that let you just murder people, okay? If murder is anything, it's extrajudicial killing, killing an innocent person. Okay, the only way you can legitimately kill someone in American society is through the death penalty, legally speaking. Okay, so the 14th Amendment, obviously, if you read it, it says no person shall be deprived of life without due process of law. Who is a person? The Supreme Court in Roe v. Wade admitted that if unborn children were persons, under the definition as the term is used in the 14th Amendment, then the whole case for legal abortion collapses, and every state should outlaw abortion because it's inherent to the Constitution. Professor George and Professor Finnis submitted a brief in which they make that exact claim. And I'm going to read from the summary of their argument. The summary of their argument is basically as follows. The originalist case for holding that unborn children are persons is at least as richly substantial as the case for the court's recent landmark originalist rulings. The sources marshaled in such decisions, text, treatises, common law and statutory backdrop, and early judicial interpretations here point in a single direction. The 14th Amendment, like the Civil Rights Act of 1866, was meant to sustain codified equality in the fundamental rights of persons, including life and personal security, as these were expounded in Blackstone's commentaries and leading American treatises. He goes on, from the earliest centuries at common law, abortion at any stage was to no lawful purpose and function as a kind of inchoate felony for felony murder purposes, and post-quickening abortion was an indictable offense. Okay, so they keep making the point that because common law, like we said in the Joseph de la Pena thing, because the common law looked at abortion as a crime, not as a right, that basically the meaning of a person, as it was understood by legal thinkers in the 14th Amendment, it included the rights of unborn children. I hope this would be the ultimate best case scenario. I don't think it's going to work, but I really applaud Professor Finnis and Professor George for making this argument to the highest court in the land that actually we should respect the right to life of every child, and that our Constitution, in fact, already protects that right. No state should deprive any person of life, liberty, or property without due process of law, and we're leading that list off with life. That will do it, my friends, for Right to Life Radio. Thank you all so much. We will see you next week. God bless, and adios.